ये वेट कर रहे हैं। ये नाराज होंगे। हो गई क्लास शुरू। बहुत बहुत धन्यवाद, आपका क्लास शुरू ला दिया मुझे। मन कर रहा है रो लूं थोड़ा सा आज। सभी बच्चे इंतजार कर रहे हैं। I hope today we'll have all in the class. Still, we are very less people in the class. Where are other lovely friends? I have joined you, my dear friend. ये लोग मुझे परेशान करके रखा है। I know that students have lots of expectation from me. And they must be hoping that I'll be joining them on right time. But due to some situation, we lost our precious time. No issue. So how was your exam? I feel like weeping due to this reason, that when I find fault in system, I'm gravely concerned and seriously worried. This professionalism is hallmark of any successful system. How was your exam? अरे बताओ पहले आरजेएस का एग्जाम कैसा हुआ? How many of you have had good exam? Please let me know. Even if you had bad exam, let me know, please. I want to see your reaction. आपका एग्जाम कैसा हुआ मुझे बताओ. Unexpected. Questions were tricky, questions were difficult. I have been traveling outside, I have not seen the question. If I can see also question, it will be good. Where is that person whom I told he will never go? Where is RJS paper? मुझे RJS का पेपर चाहिए. Some good, some bad. So it's mixed. It is upon us how do we take it. Those who fail in examination, they succeed in life. You must have heard that uh, this Bill Gates also failed in exams. You must have heard his story. And he was thrown out of his own company. And this is the same happening here. They want to throw me out of this company because they want to make the system unprofessional. And I feel bad, so someday I will have to resign. So, I don't know, many things are dependent on technical things, so I can't help it, but we have to take care of those things that there should be no technical glitches or there should be no interruption in the class due to any reason, due to me, due to my people here. आप जज हैं, जज बनेंगे नहीं, आप हैं, आप बिलीव करो आप जज हैं. ये तो सब हमारे मॉडल टेस्ट पेपर का क्वेश्चन लग रहा है मुझे. हाँ, ये तो मुझे अपने मॉडल टेस्ट पेपर का क्वेश्चन लग रहा है. अच्छा पेपर लग रहा है, इट्स गुड पेपर. Good paper, good paper. Good paper. It's good paper. मुझे तो देख के बहुत अच्छा लगा पेपर. Really good. हाँ हाँ, पेपर अच्छा जाता, रिजल्ट खराब होता है. अरे रिजल्ट क्या है, कुछ नहीं है. एक साल पढ़ने पे ना तब सही तैयारी होती है. इफ यू रीड फॉर 1 year, then you know most of the things and then it becomes सर मैं इसका एक्सपर्ट नहीं हूँ, कट ऑफ एक्सपर्ट नहीं हूँ. कट ऑफ एक्सपर्ट आ जाएंगे, अभी कट ऑफ का चर्चा हो जाएगा, डोंट वरी. कट ऑफ एक्सपर्ट मैं नहीं हूँ, मैं लॉ एक्सपर्ट हूँ, मैं लॉ पे चर्चा कर सकता हूँ. कट ऑफ पे तो मुश्किल है मेरे लिए, मैं कट ऑफ पे कभी नहीं बोलता किसी को. मैं कुछ चीज़ों में परहेज करता हूँ, जो मेरा विषय क्षेत्र है उस पर मुझे बात नहीं करनी चाहिए. मेरा विषय क्षेत्र लॉ का सब्जेक्ट है, आई शुड स्पीक ऑफ दैट. मेरे सभी बच्चे जो मुझे लगता है पेपर डिफिकल्ट होने से क्या कट ऑफ इज वेरी लो. If cutoff paper is now tricky, now it is हमारा जो जैसे ही पेपर डिफिकल्ट होता है कट ऑफ बहुत नीचे चला जाता है. तो once in DGS there were not even 500 people who could score 60%. So you can think like that because not an easy job. एग्जाम में बहुत लोग बहुत तरह से परफॉर्म करते हैं. सो आई थिंक कट ऑफ विल बी लिटिल लेस. तो कट ऑफ के बारे में ज़्यादा परेशान नहीं होना है. इज दिस क्लियर? कट ऑफ के बारे में ज़्यादा परेशान नहीं होना है आपको. अब देखिए संगम सिंह वर्सेस इलेक्शन ट्रिब्यूनल. अब मैं आपको कुछ आगे की बात बताऊं जहां तक आपने पढ़ा. आई थिंक वी हैव कवर्ड टिल ऑर्डर 9, है ना? ऑर्डर 9 तक पढ़ लिया था आपने शायद. तो टुडे विल बी स्टार्टिंग विद ऑर्डर 10, नो? नाउ टुडे विल बी स्टार्टिंग विद ऑर्डर 10. And if I see order 10, it's very simple: examination of parties by the courts. Now, once the parties have been called to the court, and then obviously court will examine them. Court will ask them questions. Court will put up matter before them. They will answer and address. And this way, court has plenty, court has WS, court has a statement of the parties. And then furthermore, in order 11, 12, 13, court will have more things. And then in order 14, on that basis, the court will frame issues. So it is necessary that, see here, at the first hearing of the suit, court shall ascertain from each party, order 10, rule 1. First hearing में क्या करेगा court? At the first hearing of the suit, court shall ascertain from each party or each pleader whether he admits or denies such allegations of fact as are made in the plaint or WS of the opposite party. क्या वो admit करता है या deny करता है allegations को? And as are not expressly or by necessary implication admitted or denied by the party against whom they are made. The court shall record such admissions and denials. तो ऑर्डर 10 रूल 1 says, बहुत सिंपल, आप अपने से ही पढ़ेंगे. ये जो अब कुछ चीजें मैं बताऊंगा ना, दे आर वेरी सिंपल, बट जस्ट हैव वन रीडिंग. At the first hearing, court shall ascertain from each party, plaintiff, defendant, whether he admits or denies allegation. No, allegation made in the plaint or WS, and are not expressly or by necessary implication admitted or denied by the party against whom they are made. The court shall record such admissions and denials. Either you will admit or you will deny. If I say something, you will admit or deny. Is this clear? I say that RJS paper was very good. So either you will admit or you will deny. So if you deny, you will show how it is not so. If you admit, then the issue is over. Clear? So it is as simple as that. There is nothing great in it. It's very simple matter. So that is what happens here in trial process also. Court shall record such admissions. तो देखो ड्यूटी क्या क्या है कोर्ट की इसमें. पहले तो कोर्ट ascertain करेगा. Court shall ascertain. So you can reframe these words. Court shall ascertain from each party or its pleader whether it admits. Court shall ascertain from parties admission or denial. Admission means you are admitting, denial means you are denying, that is, you are not accepting. of fact made in plant or WS. And as are not expressly or by necessary implication admitted or denied by the party against whom they are made. The court shall record such admissions and denial. So first duty shall ascertain, second duty shall record. ये बहुत कठिन चीज नहीं है, कुछ चैप्टर्स तो it can be easily read by you. Then it says the direction of the court to opt for any one of the mode of dispute resolution. After recording the admission and denial, the court shall direct the parties to suit to opt either mode of settlement outside the court as are specified in subsection 1 of section 89. On the option of the parties, the court shall fix the date of appearance before such forum or authority as may be opted. Obviously, alternative dispute resolution is easier method of dispute resolution, speedier method of dispute resolution, and obviously it is great alternative to long lethargic process of trial in court. So it is always preferable that you can visit that mode and you can go to alternative forum. So that is provided in section 89 of CPC, and it is beautiful provision which provides various modes of alternate dispute resolution. So settlement of dispute under the court, outside the court, where it appears that to the court that there exists element of a settlement which may be acceptable to the parties. The court shall formulate the term of settlement and give them to the parties for their observation, and after receiving the observation of the parties, the court may reformulate the terms of a possible settlement and refer the same for arbitration, conciliation, judicial settlement, including settlement through Lok Adalat, mediation. Where a dispute has been referred for arbitration or conciliation, the provision of Arbitration Conciliation Act shall apply. To Lok Adalat, the court shall refer the same to Lok Adalat in accordance with provision of subsection 1 of section 20 of Legal Services Authority Act. And all other provisions of that act shall apply in respect of disputes so referred. So what it says, that where it appears to the court that there exists element of settlement which may be acceptable to the parties, the court shall reformulate the term of settlement. So, Order 10, Rule 1A. What it says? The court shall direct parties to opt for alternate dispute resolution in section 89(1), provided in section 89(1). Provided in section 89, subsection 1. Is this clear? On the option of parties, the court shall fix the date. Court shall fix the date of appearance. Court shall fix the date of appearance before such forum or authority as may be opted by the parties. As may be opted by the parties. All right. Is this clear? Nothing great. Where it appears to the court that there exists element of settlement which may be acceptable to the party, the court shall formulate the term of settlement and give them to the parties for their observation, and after receiving the observation of the parties, court may reformulate. Is this clear? Basically, this is what is written in section 89, subsection 1. And the words, the court shall formulate the term of settlement. This is what happens in case of conciliation. So this is applicable to conciliation. This is not applicable to other things. Now, because in arbitration, it is arbitrator who will do all this. And in other methods also, judicial settlement through Lok Adalat, this is also different. This is provided in Legal Services Authority Act. Mediation also, it is not so. So it is basically conciliation. No? Are you getting the point? And if you want to learn more on this, read Afcon Infrastructure Limited case. Afcon Infrastructure Limited case. If you read this Afcon case, you will come to know about many things on ADR. You will come to know of many things on ADR. Afcon Infrastructure. Is this clear? Now, in this case, an interesting question was raised. Afcon Infrastructure Limited, this is Supreme Court decision. And in this case, very interesting question was raised in Afcon. Very interesting question was raised. And what was that interesting question? Let me tell you, in Afcon. In Afcon, a question was raised that can unwilling parties be referred to ADR? Can unwilling parties be referred to ADR? Because on this point, there is no clarity in the court that can unwilling parties be referred to ADR. So court said on this point, basically this was Kerala High Court which said that even unwilling party can be sent to ADR. Even unwilling party can be sent to ADR. But in Afcon Infrastructure Limited case, Supreme Court said that no, it is not so. And it overruled the decision of Kerala High Court. The court said that unwilling parties cannot be sent to NAM. And if you want to know more about this Afcon Infrastructure Limited case, you can read last para 25 onwards to understand it better. If you are interested in reading, if you are a student of ADR and you want to know about ADR more, which is not part of CPC exactly, ADR is a subject which is different. But you can read this Afcon case and you can learn. Later on, paras are related to ADR, basically para 25 to 45, if you want to see this. And I made an important comment. I made two important comments. Can unwilling parties be referred to ADR? I said no, Afcon has clarified this. Then I said that this section 89, subsection 1, the last few lines, if I see, the first para, last few lines, formulate the term of settlement. This is the process of conciliation. It is not applicable to arbitration, judicial settlement, mediation. No, no, no. It is basically a kind of conciliation. So this is applicable to conciliation, the terms which are written here. But obviously the reference is very clear that the court can refer the matter to, this tribunal, etc. Is this clear? Is this all right? भाई क्लियर है आपको? मेरी बात समझ में आ गई? I hope so. Is this all right? Then it says, where a dispute has been referred for arbitration or conciliation, the provision of Arbitration and Conciliation Act will apply. Obviously so. Para 41 says that. Now, to Lok Adalat shall refer the matter to Lok Adalat in accordance with the provision of subsection 1 of section 20 of Legal Services Authority Act 1987, and all provisions of that act will apply. Now, for judicial settlement, the court shall refer the matter to a suitable institution or person, and such institution or person shall be deemed to be a Lok Adalat, and all the provisions of Legal Services Authority Act. And for mediation, the court shall effect a compromise between the parties and shall follow such procedure as may be prescribed. Now, on this 2C and 2D, on 2C and 2D, there has been a clarification by Supreme Court. On 2C and 2D, there is clarification by the Supreme Court. Now, Supreme Court says that in 2C, the Act says judicial settlement, but it should be substituted by mediation. Now, in 2C, judicial settlement should be substituted by mediation. And in section 2D, mediation should be substituted by, in 2D, mediation should be substituted by judicial settlement. Because the wordings are now, see, in mediation, court shall effect a compromise. No, nothing like that. It happens in judicial settlement, and this was particularly said by Justice R.V. Ravandran and Justice J.S. Panchal in Afcon infrastructure case. So this is course correction by Supreme Court in a statutory provision of section 89. And I would like to draw your attention towards this. Courts have been doing this. I have drawn your attention earlier also that there has been correction by Supreme Court in CPC. Here is another correction by Supreme Court in CPC. In section 2C, judicial settlement should be substituted by mediation, and in section 2D, mediation should be substituted by judicial settlement. Is this clear? Mediation should be substituted by judicial settlement. Is this clear? Afcon Infrastructure Limited versus Cherian Varki Construction Company Limited 2010 8 SCC, page 24. In this case, the Supreme Court has also directed interchange of clause C and D of section 89(2) by interpretative process to correct the draftsman error so that section 89 is not rendered meaningless and infructuous. This is what I have written in your Bear Act also in brief. And Supreme Court gave detailed guidelines so that section 89 can be utilized as to achieve best result. Is this clear? Then there is Kerala State Electricity Board case where the Supreme Court has said Kerala State Electricity Board versus Kurian E. Kalathil and others, AIR 2000, Supreme Court 2573. AIR, this is written in Ambitions Bear Act. You can see on page 51, Kerala State Electricity Board versus Kurian E. Kalathil and others. Case name is not important, the ruling is relevant. It says Supreme Court observed that in absence of arbitration agreement, the court can refer parties to arbitration only with the written consent of parties, either by way of joint memo or a joint application, and not on oral consent. Not on oral consent. The Supreme Court observed that in absence of arbitration agreement, the court can refer in absence of arbitration, the court can refer parties to arbitration only with written consent. Court can refer the parties to arbitration only with written consent of parties, either by way of joint memo or a joint application, and not on oral consent given by their counsel. And not on oral consent given by their counsel. Supreme Court observed that in absence of arbitration agreement, the court can refer parties to arbitration only by written consent only. So section 89 is this one: arbitration, conciliation, judicial settlement, mediation. This is how it is written, ACJM. So you can remember also. Arbitration, conciliation, judicial settlement, mediation. Can you see this? ACJM. Arbitration, conciliation, judicial settlement, mediation. Arbitration, conciliation, judicial settlement, mediation. Is this clear? Is this all right, my dear friend? Arbitration, conciliation, judicial settlement, mediation. So now, see 1B further. Appearance before the conciliatory forum or where a suit is referred under Rule 1 is the parties shall appear before such forum or authority for conciliation. All right? Appearance before the court consequent to the failure of efforts of conciliation. So it says where a suit is referred under Rule 1 and the presiding officer of conciliation forum or authority is satisfied that it would not be proper in the interest of justice to proceed with the matter further, then it shall refer the matter again to the court. So if it fails, if it is not in the interest of justice to proceed with the matter further, maybe case is complicated or there is failure, then it will be referred back to the court because it is already a duty of court to decide the matter. Any legal dispute has to be decided. Oral examination of parties or companion. At the first hearing, the court shall, with a view to elucidating matter, with a view to extracting matter, now we will examine them orally, as it deems fit, and may orally examine any person able to answer any material question. Any person. Now you have seen this in CRPC also, you might be aware if you have read CRPC. Court can examine anyone, 311, any witness. So here also any person able to answer any material question relating to the suit by whom any party appearing in person or present in the court or his pleader is accompanied. But here it is not public matter, it is private matter. So we have written that, and is accompanied. So it can examine the parties or it can examine the other persons also, who are there with the parties. At subsequent hearing, the court may orally examine any party appearing in person or present in the court or any person able to answer any matter related to the question suit by whom such party or pleader is accompanied. At any subsequent hearing also. The court may, if it thinks fit, put in the course of examination under this rule questions suggested by other party. So, questions suggested by other party can be now asked. Substance of examination to be written. The substance of examination shall be reduced to writing by the judge. Substance of examination shall be reduced to writing by the judge. Substance of examination shall be reduced to writing by the judge and shall form part of the record. Substance of examination shall be reduced to writing. Okay, this is what is natural proceeding. The court will write down that. Consequence of refusal or unable to pleader to answer. Rule 4, where the pleader of any party who appears by pleader or any such person accompanying a pleader is referred to in Rule 2, refuses or is unable to answer any material question. If you are not able to answer any material question or refuses to answer that question and is likely to be able to answer if interrogated in person, the court may postpone the hearing of the suit, not later than 7 days. So you will be given 7 days time and direct that such party shall appear in person on such day. फिर से बुलाएगी. Where the pleader of the party, pleader of any party who appears by pleader or any such person accompanying pleader is referred to in refuses to, now he is not able to answer, pleader or any other person. Then the court will give 7 days time and direct that the party shall appear in person. The court will call the party in Rule 4. If pleader fails, party will be called. If such party fails without lawful excuse to appear, the court may pronounce judgment against him. Because if you do not oblige the court is going to punish you. Make such order in relation to the suit as it thinks fit. So, court can make order in relation to the suit as it thinks fit. Either it can pass order against you because you did not appear, or the court may now do anything else. Now, court can pass adverse order. So, this is what is order 10, a first hearing. First hearing, nothing great in this, nothing great. It's very simple, general. Nothing great. Oral examination of parties at the first hearing or subsequent hearing. Nothing great. If pleader fails to answer, or he does not answer, or he is not aware, then the party will be called. Is this clear? Just have a glance of order 10. Any issue you can ask me. No issue. We'll start with order 11 then. Is this clear? कुछ नहीं है इसमें. Just joining you. अब क्या पढ़ोगे? ऑर्डर 11 पढ़ा दूं? एक ऑर्डर काफी है. ऑर्डर 11 पढ़ा दूं? बोलो, जल्दी बोलो. ऑर्डर 11 पढ़ाऊं? अरे कोई बोल ही नहीं रहा है. ऑर्डर 11 में देखो कितनी बातें लिखी, बट कुछ भी नहीं है खास ऐसा. Now, order 11 में they have written 23 rules, but I tell you this is nothing great here. This is nothing great, I tell you. जैसे देखो आपको, now if I have taught you something, now listen to me, we are going to study order 11. If I ask you a question, if I teach you something and you do not understand the thing, after completion of my teaching, will you ask me certain questions or not? Sir, I did not understand this. What is the sum and substance of this point which you have made? What did you want to communicate? I could not understand. Or the facts are not complete, the case is not clear, whatever. So, will you ask me or not? The answer is yes. So, now order 11, it says in any suit, you will just come to know, you read rule 1. In any suit, the plaintiff or defendant by leave of the court may deliver interrogatories in writing for examination of the opposite parties or any one or more of such parties, and such interrogatories when delivered. You can deliver interrogatory, you can ask question to the other party, that is what is being said. Shall have a note at the foot thereof stating which of the such interrogatory each of such person is required to answer. If there are many persons, I will specifically now address certain question to certain persons. I want this person to answer this question, I want that person to answer this question. So, if there are many defendants and I am plaintiff, I have asked 4 questions. So, my 4 questions may be addressed to 4 different plaintiff, 4 different defendants. So, in that case, 4 different defendant will be required to answer the question. 4 different defendants will be required to answer the question. Is this clear? Provided that no party shall deliver more than one set of interrogatories to the same party without an order for that purpose. It doesn't say that you cannot, but without an order. Provided also that interrogatories which do not relate to any matter in question in the suit shall be deemed irrelevant. Which do not relate to any matter in question shall be deemed irrelevant, notwithstanding that they might be admissible on oral cross-examination of witness. So, the sum and substance is very simple, that plaintiff or defendant may deliver interrogatories with the leave of court to the other party, to the opposite party. The court's permission is required. With court's permission, you can deliver interrogatories to the other party. This is what is first paragraph in rule 1. And whenever it will be delivered, there will be a note at the foot that to whom it is addressed, which party, maybe defendant, maybe multiple, plaintiff may be multiple. Both plaintiff and defendant can raise question, can ask question, but with the leave of court. provided, now second para says, no party shall deliver more than one set of interrogatories. So you are not free to now give many set of interrogatories to the same party without an order. If you ask me one question, so you should ask all questions together. So you cannot question again and again, because that will be lethargic. And that will be now lethargic trial. We want a speedy trial. Provided also, third para, that interrogatories which do not relate to any matter in question, which is not related to the matter in question in the suit, shall be deemed irrelevant. They will be deemed irrelevant. The way which is not related to matter in question will be deemed irrelevant. Notwithstanding that they might be admissible on the oral cross-examination of witness. Notwithstanding that they might be admissible on the oral cross-examination of witness. So we will not send any interrogatories which is irrelevant, though they might be admissible on oral cross-examination of. Now, orally, in cross-examining of witness, you may put many questions. You might have read Evidence Act, what may be asked in cross-examination, section 146 and other sections are there. So there may be many questions which may be put to witness to check his veracity, integrity, something like that. Something like that. So you can ask those questions, they may not be relevant here, but in oral cross-examination it may be asked. It may be asked, but they may not be asked in interrogatories here. Particular interrogatories to be submitted. Just you read it, nothing great here, it's very simple. Court shall decide application within 7 days here. Such questions shall be allowed which will help in dispensing the case, in dispensing the justice. So it says, on an application for leave to deliver interrogatory, the particular interrogatory is proposed to be delivered shall be submitted to the court. Shall be submitted to the court. And that court shall decide within 7 days. And that court shall decide within 7 days from the day of filing of the said application. On an application for leave to deliver interrogatories, on an application for leave to deliver a particular interrogatory proposed to be delivered shall be submitted to the court. Whatever interrogatories you want to give it to the other party will be submitted, and the court shall decide within 7 days from the day of filing of said. So 7 दिन के अंदर decide करना है. In deciding upon such, the court shall take into account any offer which may be made by the parties sought to be interrogated to deliver particulars, or to make admissions, or to produce documents relating to the matter in question, or any of them, and leave shall be given as to such only of the interrogatories submitted as the court shall consider necessary. So it will not be that all interrogatories will be permitted by the court to be given to the other parties. So it says that is why court will take into account of any offer which may be made by the party sought to be interrogated. So if I am interrogating the opposite party, he makes an offer, or he makes an admission, or he makes a submission, or he says something, so we'll consider that and then we'll allow interrogatories. Obviously, principle of natural justice, you are the other party also, so here also, if you want to ask me question now, let the other party respond to that. Let the other party respond to that, and then we'll issue this. Is this clear? Then we'll issue that. So 7 दिन के अंदर court will decide this matter of leave for interrogatories within 7 days, that you mind, and then the court will also consider the offer made by the other party, admissions made by the other party, says admissions to produce document now, and then leave will be granted. Cost. In adjusting the cost of suit, inquiry shall at the variance of any part, at the instance of any party, be made into the propriety of exhibiting such interrogatory. And if it is the opinion of taxing officer of the court, either with or without an application for inquiry, that such interrogatories have been exhibited unreasonably. It is unreasonable. Vexatious. It doesn't have any substance. Or at improper length, you have asked question unreasonably lengthy. The cost occasioned by the said interrogatories and the answer thereto shall be paid in any event by the party in fault. So whoever is in fault, he will pay the cost. First it says, in adjusting the cost, inquiry shall at the instance of any party be made into the propriety of exhibiting such interrogatories. So propriety, whether it was now appropriate to ask such questions or not, and it will be decided by the court that whether it was unreasonable, vexatious, unfounded interrogatories. So if it is yes, then the party in fault will pay that. Party in fault will pay. Party in fault will pay that. Form of interrogatories. Form number 2 in Appendix C. You can see this, Appendix C. Just have a glance. Appendix D, D for decree. Can you see this? Appendix C, answer to interrogatories. The answer of the above named defendant EF to interrogations for his examination by the above named plaintiff. In answer to the said, I, the above named EF, make oath and say as follows. Can you see this? Interrogatories on behalf of above named plaintiff for the examination of above named defendant. Did not, has not. Can you see this in my barrack page 303? सवाल पूछ रहे हैं कि आपने ऐसा नहीं किया, क्या ये नहीं हुआ, क्या ये सही नहीं है, क्या वो गलत नहीं है, whatever it is. So you have come to know discovery by interrogatories. First, any party can do it with the leave of court. Is this clear? Irrelevant thing will not be asked, though it may be asked in cross-examination orally. Particular interrogatories to be submitted. Court will decide within 7 days. So heading sometimes is not correct, no? Here the main focus in Rule 2 is that the court will decide the matter within 7 days. And what matters will be looked into? So it says that we'll look into the matter that the other party is admitting this, other party is producing document. No? And leave shall be given accordingly. Cost of interrogatories. Cost. Cost of interrogatories. कौन देगा cost? In adjusting the cost of the suit, inquiry shall at the instance of any party be made into the propriety of exhibiting such interrogatories, and if it is in the opinion of taxing officer, either with or without an application for inquiry, that such interrogatories have been exhibited unreasonably, vexatiously or at improper length, तो कभी cost party in fault देगी, party in fault देगी. Is this clear? Party in fault will give that. Corporations. Where any party to a suit is corporation or body of persons. So to whom interrogatories will be delivered. So it says any member or officer. Any member or officer. In case of corporation or body of persons, interrogatories will be served upon an officer or member. Objection to interrogatories. Any objection to answer interrogatories on the ground that it is scandalous or irrelevant or not exhibited bona fide, or that the matters inquired into are not sufficiently material at that stage or on the ground of privilege, may be taken in affidavit in answer. So you can take objections that it is privileged, I am not going to address this question. Affidavit in answer. Now, setting aside and striking out interrogatories. Any interrogatory may be set aside on the ground that they have been exhibited unreasonably or vexatiously, or struck out on the ground that they are prolix, oppressive, unnecessary, scandalous, and any application for this purpose may be made within 7 days. So if you have any objection, you can make now this clear to the court that, see, this is not fair, this is not done, and we are not convinced by this fact. So you can do it. You can do it. Is this clear? You can do it. You can raise objection within 7 days. The court takes decision within 7 days, and you can raise objection within 7 days. So just see. You can raise objection within 7 days. Prolix. Prolix का मतलब होता है where you have too many words. Tediously lengthy. Tediously lengthy. Prolix. Oppressive, unnecessary or scandalous. And any application for this purpose may be made within 7 days after service of the interrogatories. After service of the interrogatories. Is this clear? Affidavit in answer filing. Interrogatories shall be answered by affidavit to be filed within 10 days or within such other time. So, answered by affidavit to be within 10 days. So, these are preliminary questions, so you can keep in mind. These are preliminary questions. These are preliminary questions. Answer within 10 days by affidavit, no? Form of affidavit. An affidavit in answer to shall be in form number 3 in Appendix C. No exception shall be taken to an affidavit in answer, but the sufficiency or otherwise of any such affidavit objected to as insufficient shall be determined by the court. These are all details, you just read them. Order to answer or answer failure. Answer further. Where any person interrogated omits to answer, answers insufficiently, the party may apply to the court for an order requiring him to answer. So if he does not answer, I can ask the court to ask him to answer or answer further. So either ask him to answer the question or ask him to further answer the question. Application for discovery of document. Any party may, without filing any affidavit, apply to the court for an order directing any other party to suit discovery on oath of document which are or have been in his possession or power relating to any matter in question. On hearing of such application, the court may either refuse or adjourn the same, if satisfied that such discovery is not necessary. So it can refuse or adjourn, or not necessary at that stage of the suit, or make such order either generally or limited to certain classes of documents as may in its discretion be thought. This is the rule 12. Application for discovery of document. Is this clear? Is this all right? Affidavit of document. Affidavit to be made by a party against whom such order as is mentioned in the last proceeding rule has been, shall specify which of the documents there mentioned he objects to produce, and it shall be in form number 5 in Appendix C with such variations as circumstances may require. Production of documents. It shall be lawful for the court at any time during the pendency of any suit to order the production by any party thereto, upon oath of such of the documents in his possession or power relating to any matter in question in such suit, as the court shall think right, and the court may deal with such documents when in such manner as shall appear just. When produced in such manner, आप ऑब्जेक्शन भी कर सकते हैं. Which of the documents therein mentioned he objects to produce. So if you give application for discovery of document, there can be objection further. Production it shall be lawful for court any time during the pendency of to order production. The court can further interfere. Inspection of document referred to in pleading or affidavit. Every party to a suit shall be entitled at or before the settle to give notice to the other party in whose pleading or affidavit references is made to any document or who has entered any document in any list next to or produce such document for the inspection of the party giving such notice or of his pleader and to permit him or to them to take copies thereof, and any party not complying with such notice shall not afterwards be at liberty to put any such document in evidence. See, you will be debarred. This is also rule in evidence. Now you can read this carefully. What it says, every party shall be entitled at or before to give notice to other party. This is there also in evidence law, that you can give notice to other party to produce document. Reference is made to document. So if you have made reference to document in your pleading, you can be asked to produce. Or who has entered any document in any list next to his pleading. So if there is a reference in your pleading, or there is a reference in annexure of pleading, or produce such document for the inspection of the party giving such notice, or of his pleader, and to permit him or them to take copies thereof. So it is your duty as a party that if you have been asked to produce, first it says every party shall be entitled to give notice in whose document, in whose pleading or affidavit there is reference of document. Is this clear? And to permit him or them to take copies. So other party can take copies also. Or any party not complying with such notice, if you have been asked to produce and you do not, shall not afterwards. So did you understand? Shall not afterwards. You will be debarred. He shall now, unless he satisfies the court that such document relates only to his own title, he being a defendant to the suit, or that he had some other cause or excuse. So he can satisfy the court, then he can produce, otherwise he is barred. Is this clear? I have given you notice to produce document which you have referred in your pleading or annexure of pleading. So why are you not producing it? If you are not producing it, then you will be barred to produce it later on, unless and until the court allows you. So this is very genuine rule, nothing great in it. It's very simple, general. If I am doing something wrong, can I take advantage of that thing later on? The answer is no. I can't take benefit. Three kinds of documents basically being talked about here. तीन प्रकार के डॉक्यूमेंट की चर्चा हो रही है. रेफर्ड इन प्लीडिंग, डॉक्यूमेंट रेफर्ड इन नेक्स्चर एंड अदर डॉक्यूमेंट. So you can now see this carefully. Non-compliance with order for discovery. This is written in Rule 21 also. So you can write down this. Basic points you can write down. Tell you. In this context, there are three documents. In this context, there are three documents. First, referred in pleading or affidavit. Second, document referred in annexure. To pleading. And third, other documents. So, now on these two things, other party can ask you to produce. Other party can ask you to produce. Can ask you to produce. On this, it is not. But here, on these two, The other party can ask. But about other documents, he cannot ask. As you have said it in pleading or you have referred it in pleading, so it is now it is right of other party to ask you to produce these documents. You generate right in favor of other party because you have brought it in pleadings. You have brought it in pleadings, so you are bound to now. Is this clear? Is this all right? Referred in pleading, document referred in annexure of pleading. So other party can ask you to produce. But on other documents, no. You cannot. There the other party has no right. Notice can be given before settlement of issue. This notice of, or what do you say this? Discovery of document, no? Discovery, notice of inspection. Uh, Reference is made to each party should be entitled to give notice, no? Rule 15 basically, or at or before this notice of this notice of production of document can be given to, this notice of production or document can be given to this notice of production of document can be given to other party before settlement of issues. Before settlement of issues. If not complied, if there is non-compliance, plaintiff's fault. If plaintiff is under default, see, this can be a question. Suit liable to be dismissed. Dismissal of suit. Correctly so. Plaintiff has mentioned these documents in his suit and he does not produce that. So plaintiff's default, dismissal of suit. Defendant's default. Defendant's default. Defense of defendant liable to be struck. Defense of defendant liable to be struck. Defense of defendant liable to be struck. Defense of defendant. Defense of defendant liable to be struck. 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 So if defendant is not producing that, so his defense will be struck down on that point. Correctly so. So obviously, if you do not perform, then you will be liable to be punished. Is this clear? You are liable to be order for now, then notice to produce, you see this, and this is written in Rule 21, you can see this, where any party fails to comply with any order to answer interrogatories or discovery for inspection of document, answer interrogatories or discovery or inspection of document, he shall, if the plaintiff be liable to have his suit dismissed for want of prosecution, because you are not now bona fide in your prosecution, and if defendant to have his defense, if any, struck out, and to be placed in the same position as if he had not been defended. So on that point, he will not be defended. And the party interrogating or seeking discovery or inspection may apply to the court for an order to that effect. Party can apply to the court that you please pass the order of dismissal of suit or this defense to be struck down. An order may be made on such application accordingly after notice to the parties, after giving them a reasonable opportunity of being heard. Is this clear? Is this all right? तो कोई बहुत बड़ी बात, if I am relying on any document, if my claim is based on any document and I am not producing that, is it not bad? How can I claim? I should be penalized. I should be penalized. Time for inspection, Rule 17, when notice given. Time, the party to whom such notice given shall within 10 days from receipt of such notice delivered to the party giving the same in notice, is stating a time within 3 days from the delivery thereof at which documents or such of them as he does not object to produce may be inspected at the office of his pleader, or in any case banker's book or other books of account or books in constant use for the purpose of any trade or business at their usual place of custody. You can go and you can check it there, books of account. And is stating which, if any, of the documents he objects to produce. If there is any objection, he will produce that objection, he will state that objection, and on what ground. So time for inspection. So the party to whom notice is given for inspection, within 10 days from the receipt of the notice, he will deliver to the party giving the same a notice stating a time within 3 days. So he will be given time of 3 days for inspection. Let's see, you have this document here and you can do it here. Is this clear? Is this all right? कुछ ऐसा तो नहीं है बहुत खास. Don't think that there is anything great. You can read it. There is nothing great now. Order to apply to minor. The order shall apply to minor, plaintiff, independent, and to the next friend and guardians for the suit of persons under disability. Yes. So it will be their duty. It will be their duty. Commercial division of High Court or commercial court. You can see. Here also the rules are there. But that is special, specific. Now, order 12 is about admission. If you admit something, then there is no requirement of proof. Admission is proof. So it's very simple. I'll talk about this furthermore, but you just read it here also. Admission. अब देखो preliminary में भी question आते हैं इसके. Preliminary questions are also there. Order 1011, if you have any doubt, please. Order 1011, if you have any doubt, please ask me right now. Order 1011, if you have any doubt, please ask me right now. Order 1011. Then I will talk of order 12. जानकारी के लिए ये सब, whatever is relevant factual information, 10 days, 3 days, 7 days, that you have to see once. Nothing great. Order 1011 कोई issue नहीं है. इज देयर एनी मैसेज? मेरे को नहीं दिख रहा है क्या? 7 बजे का मैसेज दिखा रहा है। क्या करें? ऑर्डर 2 रूल 21 सब रूल 2 देन वेयर कैन बी फाइल्ड फ्रेश शूट ऑन सेम कॉज ऑफ एक्शन? शूट ऑन सेम कॉज ऑफ एक्शन। ऑर्डर 10 रूल 21, ऑर्डर 10 रूल 21 क्या है? 10 रूल 1, ऑर्डर 10 रूल 21 तो है ही नहीं आरती। लिखा तो ऑर्डर 21, ये आपने गलत लिख दिया शायद। ऑर्डर 11 है, वेयर एन ऑर्डर इज मेड अंडर सब रूल ऑन डिसमिसिंग एनी सूट, द प्लेंटिफ शैल बी प्रिक्लूडेड फ्रॉम ब्रिंगिंग ए फ्रेश सूट ऑन द सेम कॉज ऑफ एक्शन। आप गलती करोगे, आपको थोड़ी बार बार कोर्ट को वैक्स करने देंगे। लिखा था है ऑर्डर 21, ऑर्डर 10 रूल 21 सब रूल 2, plaintiff is precluded. Now the point is very simple. If you have done something wrong, if you have done something wrong, it is order 11 rule 21. You have written order 10. So koi nahi, where an order is made that now plaintiff is under fault, why will be allowed to bring a fresh suit on the same cause of action? हाँ? जैसे देखो कॉमन सेंस में हम लोग समझते हैं ना, if you are absent from the class, should you be allowed to have class again? The answer is no. Why did you absent yourself? So why did you commit wrong? Why did you committed fault? So this should not be done. This should not be done. This is what is being said. You will have to seek other remedies. You want remedies now? You will have to seek other remedies. You can find alternative remedy. But you will not be allowed to bring a fresh suit. He cannot be allowed to file fresh suit on same cause of action. No, 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 not at all. Now you commit wrong and you say, I want to have my right prosecuted, or if I have my right to be decided by the court. No, no, no. Why? Why? क्यों आपने गलत किया बताओ? आप ही ने गलत किया ना, तो आपको क्यों हम बार बार उसका बेनिफिट दें? Why should you be given benefit of wrong committed by you? आपको हम बेनिफिट क्यों दें उसका बताओ? Why should I give benefit to you for committing wrong? नहीं, ये कोई section numbers are important for free and general glance. Which section number? Which? आपको प्रीवियस ईयर क्वेश्चन देखने के लिए तो मैंने बोला, आप भी आप वही फिर वही कहानी पुरानी वाली पूछ रहे हैं। आपको कितनी बार बताया कि प्रीवियस ईयर क्वेश्चन देख लो, सब क्लैरिटी आ जाएगा। ये पूछने से क्लास में कोई फायदा है? मैंने तो आपको कितनी बार बताया रजत जी, हम ऐसे नहीं हो सकता कि ये रूल पढ़ लो वो रूल पढ़ लो। आपको सीपीसी समझना है भाई, आप सीपीसी समझ रहे हो। ऐसे थोड़ी है कि बच्चों को खेल है कि भाई ये 4 सवाल पढ़ लो और यही 4 सवाल में से एक आ जाएगा एग्जाम में। ये अब जमाना नहीं है भाई, ना 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 ना। आप जज बनने जा रहे हैं सर, आपको सीपीसी की प्रक्रिया समझनी है। एंड वन हु अंडरस्टैंड्स द प्रोसेस एंड द प्रोसीजर, now they will be able to solve it. That is not at all an issue. I know it very well, but for that you will have to practice, practice, practice. I have told you to practice hard. I have told you to solve questions. I have told you to make list of factual information. I have told you to understand the process. ये understanding of process चल रहा है अभी, बहुत आराम आराम से पढ़ रहे हैं हम लोग। इज दिस क्लियर? अब ऑर्डर 12 में बहुत तरह के एडमिशन हैं, आप देखो। देखो एक आपको दिखेगा, जैसे देखो ऑर्डर 12 को पढ़ो, देखो कैसे प्रिलिमिनरी के सवाल आते हैं। आप पूछ रहे हो ना रजत जी, आप पहले समझो बात को। रूल 1 से नोटिस ऑफ एडमिशन जब भी पढ़ो तो यू कीप योर आईज एंड माइंड एंड ईयर ओपन। नो नोटिस ऑफ एडमिशन ऑफ केस। दूसरे में क्या लिखा? नोटिस टू एडमिट डॉक्यूमेंट्स। ओ ऑल राइट। देन फोर्थ में क्या लिखा? नोटिस टू एडमिट फैक्ट्स। तो केस, you will have to accept the case. Document a particular document. And fact a particular fact. So there are three different things. Now, preliminary may ask you which rule talks about notice of fact. अब आप देखो ऐसे रटोगे तो नहीं होगा. F for fact, F for 4. I remember 4. This is how preliminary has to be passed. Now I know admission is in order 12. I know that. Order 12, rule 4 talks of admission of facts. अब बताओ C and D. In alphabet, which comes first? C comes first. And the rule is 1 to ka 4. So 1 to ka 4. So 1 to ka 4 talks about notice of admission. 1 to ka 4. So 1 is one admission case, 2 is another admission document, and 3 is another, 4 is another admission, that is fact. Here it is not 1 to ka 3, 1 to ka 4. गाना तो सुना ही होगा, you must have heard this song, 1 to ka 4. तो कर दिया 1 to ka 4. And F for 4 and F for fact. तो rule 4 में fact. Rule 4 में fact. Clear? Rule 4 में fact. 1 to ka 4. TDF. 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 Case document fact. Case document fact. Case document fact. Clear? Clear, my dear friends? अब देखो तुम्हें रूल 1 to का 4 सिखा दिया ना. 1 to का 4 भूलोगे तो नहीं. Admission of case, अब तुम अपने से भी पढ़ो. You read yourself. Any party to suit may give notice by his pleading or otherwise in writing that he admits the truth of whole or any part of the case. Whole of the case or part of the case. So both are admission of case. Then notice to admit document. Either party may call upon other party to admit within 7 days time from date of service of notice any document saving all just exception, and in case of refusal or neglect to admit after such notice, the cost of proving any such document shall be paid by the party so neglecting or refusing, whatever the result of the suit may be, unless the court otherwise directs, and no cost of proving any document shall be allowed unless such notice is given, except where the omission to give notice is, in the opinion of court, a saving of expense. So you will have to give notice except the court says that it is for saving of expense. Is this clear? Either party. No cost of proving any document shall be allowed unless such notice is given. And admission of document means admission of fact. Admission of document means Admission of document means admission of fact contained in the document. Admission of document means admission of fact contained in the document. Power of court to record admission. So, ये पढ़ेंगे अभी. Notice to admit facts. See rule 4. Any party may by notice in writing or at any time not later than 9 days before the day fixed for the hearing call on the other party to admit for the purpose of the suit only any specific fact or fact. And in case of refusal or neglect to admit the same within 6 days after service of such notice. तो चलिए आप पढ़िए इन सब चीज़ों को. ऑर्डर 12 रूल 6 में लिखा है जजमेंट ऑन एडमिशन. मैं इसको फिर से आपको डिटेल में थोड़ा पढ़ाऊंगा, स्पेशली ऑर्डर 12 रूल 6, बट आई विल रिक्वेस्ट यू टू सी ऑर्डर 12. Order 12 rule 6 is very important, which says where admission of fact have been made either in the pleading or otherwise, may at any stage of suit, either on the application of party or on its own motion, without waiting for the determination of any other question between the parties, make such order or give judgment as it may think fit, having regard to such admission. Is this clear? So it can be done at any point of time. Any point of time. I'll talk about this admission tomorrow in detail because admission is important. Again, rule 13, order 13, 14 are not so detailed, so you should not worry at all. But order 12 is a little relevant in this, especially order 12 rule 6. So I take your leave here, my dear friend. I'll join you tomorrow, and I hope tomorrow will be exact on time because it looks very bad if I do not join you on time, and I have to complete the trial process tomorrow. There is nothing left in trial process as such. So we'll be completing the trial process. We are going to now fix this order 14, determination of issues. 15 is disposal on first hearing. If you do not dispose, then you will call the witnesses. Witnesses can depose before you by affidavit also. And then there is judgment, decree or order. This is what completes the trial process. So we'll complete that. And post-trial process, we'll talk after you read little bit of special suits. Then we'll come back and we'll talk about that again. Is this clear? घबराने का नहीं है, बने रहने का है. Is this all right? Is this clear, my dear friend? Is this all right, my dear friend? Tell me. प्लीज आप लोग बोलते नहीं क्या हैं? कुछ बोलते ही नहीं, कुछ बताते ही नहीं हो, पता नहीं इतने नाराज हो कि बात भी नहीं कर रहे हो. When the people are angry with you or they are not happy with you, they do not talk to you. I have seen this general tendency. So is it the case here? Are you not happy with me? So you're not talking to me. And again, there are only less people today in the class. I don't know why less people in the class. Why others are unhappy. Now, can you communicate to others that please they should join me tomorrow, because tomorrow's class is very, very important. I'll be dealing with culmination of trial process. I'll be dealing with culmination of trial process tomorrow. I'll be dealing with culmination of trial process tomorrow. My dear friend, please be careful about this fact. I'll be dealing with the culmination of trial process tomorrow, so please ask everyone to join me tomorrow in my class, rather in your class, sorry. Great, 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 great. Taima Tayyab, Annapurna, Sandhyali, Radhika, Rajat, Sheikh. पढ़ते रहो रजत, घबराने का नहीं है. आप लोग परेशान होते हो, ये क्वेश्चन कौन से सेक्शन इंपॉर्टेंट, पहले एक बार पढ़ो, सीपीसी को पढ़ो अपने आप ना. एक समय आएगा, यू विल कम टू नो. ऐसे नहीं होता कि ये वाला सेक्शन पढ़ो, इसलिए घबराने का नहीं. पढ़ो, अभी पढ़ो. यू जस्ट डू इट, जस्ट रीड विदाउट थिंकिंग मच. Just try to understand CPC. Just try to understand CPC. उत्कर्ष ओझा, प्रेरणा डिंगरा, आदित्य, अजय चौधरी, रजत, अभिषेक ठक्कर, सोनिया सुमन, अभिषेक ठक्कर, अरोरा, किरण अग्रहरी, प्रवीण यादव, श्रुति, निगदा, शुभम चौहान, निकी बैद, प्रशांत सिंह, श्वेता कश्यप, कशिश मुंजाल, अल्फिशा सैफी, आंचल तिवारी, भूमिका मचान, जिया चौधरी, राज रत्ना, उमले, कीर्तिमान द्विवेदी, साक्षी सिंह राज रत्ना, आई एम सीरियसली सॉरी, बहुत मुश्किल होता है बैरक प्रिंट कराना, मैं बता रहा हूँ, जब तक मैं पढ़ूंगा नहीं, मैं पढ़ ही नहीं पा रहा हूँ, आई एम बिजी, many works, Spriha, Shreya. I'm a social worker, also a teacher as well, so I have great difficulty in doing many things at same point of time. सर नाज मैं बट मैं अपने सोशल सर्विस को भी नहीं छोड़ सकता, मेरी ये प्रॉब्लम है, अदरवाइज आई विल फील आई विल रिपेंट इवन आफ्टर आई डाई, सो आई विल नेवर लीव इट. I do little bit of social service, so I enjoy it, and that is why my academic work suffers sometimes, but I have to balance. क्वेश्चन फैक्ट से रिलेटेड होते हैं, उसकी आंसर राइटिंग कैसे करते हैं आप एक बार लिख के देखो, एक बार लिख के देखो. पहले तो कोई भी लॉ का क्वेश्चन होगा, यू विल हैव टू राइट लॉ एंड देन यू विल हैव टू अप्लाई लॉ इनटू द फैक्ट. so if you can show me, if you can now send me a question, I can check it, no issue, no issue. I can see that question, I can tell you, my dear friend, it is not anything great, you just start writing. No, nothing great in it, my dear friend. हाँ, स्पीडी इन टीचिंग, अरे ये मुझ पे छोड़ दो, कुछ है ही नहीं तो पढ़ाऊंगा, टाइम थोड़ी पास करना है क्लास में. दिस इज माय जॉब, यू डोंट वरी. आई नेवर डू these थिंग्स, यू विल हैव टू बिलीव मी फॉर सर्टेन. अब भाई कहीं कुछ पढ़ाने के लिए आई नहीं तो जबरदस्ती पढ़ाऊंगा थोड़ी ना मैं. मैंने आपको पहले ही बताया होगा, ऑर्डर 1 to 7 बहुत क्रक्स है, उसमें बहुत मैटर है. बट अब लेटर ऑर्डर्स में मैटर नहीं है, अब मैटर फिर आएगा आगे, एग्जीक्यूशन. आप उसकी चिंता मत करो, आप पढ़ो, आप क्वेश्चन बनाओ, आप कॉन्सेप्ट समझो. इफ यू फाइंड एनी डिफिकल्टी इन अंडरस्टैंडिंग एनीथिंग, यू लेट मी नो, विल वर्क अपॉन दैट. एंड आई एम वर्किंग ऑन मेनी थिंग्स, आई विल टेल यू. मैं आपको क्वेश्चंस भी दूंगा, अभी आपकी सीपीसी की क्लास में बहुत कुछ और होगा, अभी डोंट वरी, अभी बहुत कुछ होना बाकी है. मैं क्वेश्चन भी सॉल्व करवाऊंगा, मेरे अभी कुलिक्स हैं यहाँ पर जो आपको क्वेश्चन सॉल्व कराएंगे इसी क्लास में, तब आपको और क्लैरिटी आएगी, डोंट वरी. I will get it done, don't worry my dear friend, so you should not worry about that. Is this clear? मेरा सारा वही उड़ गया मैसेज तो. ठीक है.